The following podcast is by Mr. Jim Koewler, elder law and special needs attorney, helping and protecting those who need long-term care. And welcome back, everyone, to Answers for Elders Radio Network. And we're here talking with Jim Koewler, elder law attorney in the state of Ohio, and our favorite one here on Answers for Elders. And Jim and I are talking about those important individuals that we need to have around us in our later life. And we've talked about powers of attorney. We have talked about different forms of executorship and things like that. And now, Jim, you're going to talk about trusts. And that's a whole other piece, because there's different forms of trusts, aren't there?
Yes, there are, because they serve different purposes. So let's talk about the revocable trust first.
Okay.
Revocable is your garden variety. I don't want my estate to have to go through probate court. So I'm going to have a lawyer set up a trust for me, and the trust is going to own pretty much everything I have of value. And then it's all handled under the contract terms of trust, because the trust agreement is just a contract. Okay?
Right.
It's a contract between the trustee, the person taking control, and the grantor, the person creating the trust.
Correct.
And to some extent, the settler, the person creating the trust, and to some extent, all the grantors who then put things into the trust, and the settler is usually the grantor. Okay. But not always. With a revocable trust, it's almost always the grantor or the settler are the same, but we'll get into when it's not in later in this segment or in the next. So it may, for a garden variety revocable living trust, the trustee and the grantor / settler may be the same person, the same couple. So it's a contract with themselves individually, with themselves as trustees. Okay, so, but the contract is what allows the assets held in trust to avoid probate court. It's not very different in this way than a life insurance policy. A life insurance policy is a contract with an insurance company. You give them money, they promise to give it back when you die to whomever you say. And whether the insurance company makes money depends how long you live, and whether the economy's good, and blah, 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 blah. Okay. That's not what we're talking about here. We're simply talking about, you set it up, you have a contract. A life insurance policy is a contract with that company. And then the contract, assuming you don't cash it out along the way, the contract is then triggered to empty out the value of the policy upon your death. So obviously we're talking about life insurance policies here, folks. Okay. Well, that doesn't have to go to probate court unless you name your estate in the policy. Then why'd you have a policy in the first place? Because that's just not okay. The only way it's not nuts is if all of the beneficiaries you did choose died before you did, and then it's going to end up in your estate just for lack of any other place to go. And okay, that happens sometimes. Okay, but a revocable living trust is the same sort of thing. A contract controls what happens to the contents of the trust, just like an insurance policy contract controls what happens to the money inside the insurance pool, the fund, the policy. Okay, so it avoids probate court because the contract controls everything inside it. Now that's assuming whoever set it up actually put stuff in it. There are thousands of empty trusts out there where somebody did all the work to set it up and then never funded it.
That's kind of bizarre, but I can imagine.
It's closing the loop, and it's the part of the loop that the lawyer can't do. The lawyer can urge, cajole, nag, fuss, but the person has to go to the bank and say, hey, bank, here's my trust, change the name on my account, or open me a new account, move everything, or whatever. Okay. That's the part that is the follow through of the client.
Sure.
And sometimes clients don't follow through because they don't understand. But we'll assume we have a funded trust. Well, okay. Remember, we're choosing this person at the time we write the trust anyway. So funded or not funded, their personality traits are the same because we hope it's funded. Okay. Yep. So with a revocable living trust, generally the initial trustee is the settler and grantor who set it up, or the married couple. Because again, like I said, they're simply contracting with themselves as individuals, with themselves as trustees, as a way to get this stuff into trust and avoid probate court, have their family avoid probate court after they die. So The initial trustee is almost always the grantor slash settler. Settler, again, the person who created the trust agreement, all the person or people who put stuff into the trust. Okay, who owned the assets before they got there. Okay, but so choosing myself as the trustee, that makes perfect sense. That's easy. Okay, because I built it for myself. The successor trustee is where it gets tricky. Okay, so this is someone who will take over as trustee if the initial trustee or trustees are gone, passed away, or unable to continue as trustee for mental health or physical health reasons, or they simply resign. They can also resign, say, I turn it over to the successor trustee, which is fine. Okay. This is similar to an executor because this is a business job.
Sure.
Because most of what they're going to have to do while the grantor settler are still alive is simply, when the settler grantor asks for money, give it to them. Okay, that's easy because while the grantor settler is still alive, they're the only beneficiary during the life for themselves. So there's no fights with anybody else. Okay, but once that all the grantors and settlers are gone, so both parents are gone, let's say, now it's a matter of winding up the trust, and it's very much like a will in this way. It's just a trust instead of a will.
Sure.
Remember, that's what a revocable trust is for, to be instead of a will. Okay. So you're looking for someone who gets stuff done, meets deadlines, and doesn't buckle under pressure from others.
Same thing.
You see here in my notes,
same
just
quality.
like the executive will. So,
what about, I've heard about hiring attorneys to be trustees. I've heard about banks being trustees.
Yes. Okay. So attorneys and banks can be trustees in one, assuming they agree. Just like with powers of attorney, don't ambush somebody. That's not fair. Okay. Especially someone who deserves to get paid, like a bank or
an accountant.
attorney.
There's another
The
one.
bank's not going to touch it unless they got an agreement with you anyway. Okay. So an attorney and even more so a bank or trust company is going to want instructions quite clear on how they make decisions of spending stuff out of the trust and how risky an investment can they make with the stuff inside the trust, because they don't want to get sued by unhappy heirs who thought there was going to be more money there, or who are unhappy that a certain amount of money, let's say it's not even a sentimental asset, it's just a certain amount of money went to cousin Billy, and hey, Billy has his own parents. Don't let Billy dip into our stuff. But if mom and dad set it up that way, that cousin Billy gets some. But that doesn't mean the trustee won't get sued.
Sure.
And we will see this even more when we talk about irrevocable trusts. But the bigger the trust, I'm sorry. So we'll see it more when we talk about irrevocable trust, because third parties struggle with discretion. If distribution is you may distribute when XYZ, or you may distribute when you feel like it.
Sure.
They struggle with that because of their duties to protect the value of the trust, both for the current, the people who can use the trust during their lifetimes. So the lifetime beneficiaries, in this case, the married couple who set it up, okay, and the residual beneficiaries who receive what's left after the initial beneficiary, the lifetime beneficiaries are gone. So every use of discretion can get tricky and put them at risk. And they don't like risk. They're banks and they're attorneys. At least they don't like the risk of them being sued. They may help take other risks, but they're not going to take risks themselves. So those are very, very tricky. But if you have enough in there that you want professional management of the funds, it makes sense to go to a bank or a trust company. If you have a special use of that trust, and we see this especially with things like special needs trusts, you may want to have an attorney that knows their way around the special needs world, for example. Okay. And that makes some sense. Now, we'll talk about this some more when we hit irrevocable trusts, which has got a lot more nuances in it. But you may want someone who can focus on the purpose of the trust, where with revocable living trust, the purpose is just to avoid probate court.
Yeah.
Okay. And the rest of it simply, how would I manage my money if I were mom and dad? And that's an okay way to approach it. Unfortunately, that disagrees. Well, you weren't a prudent investor. And okay, now we run into a problem because what mom and dad want may not have been prudent, but the residual beneficiaries can demand a prudent investor slash trustee. Yeah, that gets ugly. So the longer mom and dad can do it, the safer it is for everybody, because the kids can't sue mom and dad for mishandling it, because it was never kids to begin with. It was always mom and dad.
Right. So when someone has a family trust, is that usually a revocable trust?
Assuming that family trust means the same in Washington as it means here.
Okay.
And let me preface my comments by saying that's reasonably high level estate planning stuff. And I focus on people who need long-term care and people with special needs. So I don't do high level estate planning stuff, but things trusts that go beyond the simple, let's avoid probate court, tend to be irrevocable in order to get the benefits that you want. For example, a charitable remainder trust. If you could revoke it, then IRS is never going to recognize it as charitable remainder trust.
Right.
A Medicaid asset protection trust. If you can revoke it, then Medicaid's going to say, revoke it and spend the money before we start paying. So and then a family trust, which is supposed to look out for family 2-3 generations down the line, or a bloodline trust, same sort of thing, but it cuts out in-laws. Okay. Or a legacy trust, which is really kind of a wide open concept. There isn't one thing.
That's for people with lots of money.
Okay. And we're talking about huge bucks here. So so professional management makes perfect sense, but it's going to have to be irrevocable for it to have the creditor protection that you're looking for over generations.
And we're going to talk about irrevocable third-party trusts coming up on our next segment. And Jim and I will be right back right after this. State of Ohio residents, you have a friend to help you navigate long-term care while protecting your assets. You can reach Jim at www.protectingseniors.com or just email him at jkoewler-afe, that's jkoewler-afe at protectingseniors.com.